Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Statutory Rape Lawyer, Chicago, Illinois. If you're facing statutory rape charges in Chicago, Illinois, it's critical to hire a criminal defense lawyer as soon as possible. A statutory rape charge conviction in Illinois can lead to severe criminal penalties, including prison time, mandatory sex offender registration, and long-term damage to your reputation and future opportunities. Whatever the circumstances surrounding your case, the experienced criminal defense attorneys at Combs Waterkotte are here to help you build a strong legal defense. At Combs Waterkotte, we understand how overwhelming and life-altering these allegations can be. Our team has decades of combined experience defending clients against serious felony-level sex crime charges throughout Illinois, and we're prepared to fight aggressively to protect your rights, freedom, and future. Call 312-500-HELP today to discuss your case with a statutory rape lawyer serving Chicago and Cook County, Illinois. Statutory Rape Lawyer in Chicago, Illinois, serving all of Cook County. A statutory rape charge in Chicago, Illinois can turn your life upside down fast. These allegations often involve complicated circumstances, misunderstandings, or disputed facts. But prosecutors in Cook County aggressively pursue guilty pleas in sex crime cases. A conviction can lead to years in prison, mandatory sex offender registration, and permanent damage to your personal and professional reputation. You need a criminal defense team that understands how high the stakes are and knows how to fight back. At Combs Waterkotte, we've spent decades defending clients accused of serious felony offenses throughout Cook County and the greater Chicago area. When you trust our firm with your statutory rape case, we begin with a free, confidential consultation to hear your side of the story and evaluate the details of the allegations against you. From there, our experienced attorneys, law clerks, and legal staff get to work building a defense strategy tailored to your case. We carefully examine witness statements, digital evidence, police procedures, and every aspect of the prosecution's case to uncover weaknesses that can help get your charges reduced or dismissed. If necessary, we're fully prepared to take your case to trial and fight for a not guilty verdict. If you're ready to protect your future and defend your rights against statutory rape charges in Chicago, Illinois, or anywhere in Cook County, contact Combs Waterkotte online or call 312-500-HELP today. The sooner you secure experienced legal representation, the better your chances of achieving a favorable outcome. Statutory Rape Definition in Chicago, Illinois. The Illinois Criminal Code does not have a single definition or statute outlining exactly what statutory rape is. Instead, the criminal conduct that constitutes statutory rape is covered under several different statutes under Illinois law. The main focus of these statutes tends to revolve around the ages of the victim and alleged perpetrator, whether penetration was involved, whether force was involved, incestual acts, whether a defendant occupied a position of trust or authority over an alleged victim, whether any aggravating circumstances existed. Article 11 of the Illinois Criminal Code does outline some sex offense terms that are used throughout the state's statutory rape-related criminal laws. The definitions of these terms exist under 7 2OILCS 5/11-0.1 and include the following. Minor, any person under the age of 18, definition borrowed from 720 ILCS 5/11-21 AA. Sexual conduct. Knowing touching or fondling of the sex organs, anus, or breasts by the victim or the accused, either directly or through clothing. Sexual penetration. Any contact between the genitals or anus of one person and an object, genitals, mouth, or anus of another, or the intrusion of the sex organ or anus of one person by another. Force or the threat of force, the use of violence or threat of violence against a victim, or overcoming a victim using physical restraint or confinement. Child sex offender. Any individual who has been convicted of sex crime offenses outlined in 720 ILCS 5/11-9.3 D1 against a victim under 18 years old. Offenses include, but are not limited to, child luring, indecent solicitation of a child, sexual exploitation of a child, child pornography, aggravated child pornography, traveling to meet a minor. While these definitions are at the core of what constitutes statutory rape in Chicago and Cook County, Illinois, the criminal laws around the offense outline the actions that determine statutory rape. Statutory rape laws in Chicago, Illinois. Statutory rape in Chicago isn't defined in a single statute, but rather across several statutes that cover the entire spectrum of child sex crimes. The closest thing Illinois has to a statutory rape law is predatory criminal sexual assault of a child. Under 720 ILCS 5/11-1.40, someone commits this offense when the offender is at least 17 years old. The offender sexually penetrates or partakes in sexual conduct with a victim under 13 years old. Illinois' criminal sexual assault law also has sections regarding age-related offenses. According to 720 ILCS 5/11-1.20, criminal sexual assault in Chicago, Illinois is defined as an act of sexual penetration that occurs when the offender uses force or the threat of force, or when the offender knows the victim can't consent. The statutory portions of the criminal sexual assault law cover offenses committed against minors. These parts of the law include 720 ILCS 5/11-1.20 A3, criminal sexual assault by a family member of a victim who is under 18 years old. 720 ILCS 5/11-1.20 A4, criminal sexual assault by an offender who is 17 years of age or older and holds a position of authority or trust over a victim between 13 but under 18 years old. The crime of aggravated criminal sexual assault occurs in Illinois when an offender commits criminal sexual assault alongside other violent factors, like using a deadly weapon, causing bodily harm, or drugging their victim. This statute, 720 ILCS 5/11-1.30, also covers age-related statutory rape offenses, including 720 ILCS 5/11-1.30 BB-I, aggravated criminal sexual assault when the offender is under 17 years old and sexually penetrates a victim under 9 years old. 720 ILCS 5/11-1.30 AB-2, aggravated criminal sexual assault when the offender is under 17 years old and sexually penetrates a victim between 9 and 13 years old while using force or the threat of force. Interestingly, age-related aggravated criminal sexual assault offenses cover sex offenses committed by minors against other minors. Illinois' criminal sexual abuse statute, 720 ILCS 5/11-1.50, covers similar offenses. A person commits criminal sexual abuse when they partake in sexual conduct by force or using the threat of force. The following portions of the law cover age-related scenarios. 720 ILCS 5/11-1.50b. Criminal sexual abuse when the offender is under 17 years old and commits the offense against a victim between 9 and 17 years old. Criminal sexual abuse when the victim is between 13 and 17 years old and the offender is less than 5 years older than the victim. 720 ILCS 5/11-1.60 outlines aggravated criminal sexual abuse, which occurs when an individual commits criminal sexual abuse alongside other violent factors, drugging a victim, using a deadly weapon, or causing bodily harm. This law covers several instances of age-related statutory rape, including 720 ILCS 5/11-1.60b, aggravated criminal sexual abuse against a family member under 18 years old. 720 ILCS 5/11-1.60c1I, aggravated criminal sexual abuse against a victim under 13 years old. 720 ILCS 5/11-1.60c1-2, aggravated criminal sexual abuse against a victim between 13 and 17 years old, involving the use of force or threat of force. 720 ILCS 5/11-1.60c2-1, aggravated criminal sexual abuse where the offender is under 17 years old and the victim is under 9 years old. 720 ILCS 5/11-1.60c2-2, aggravated criminal sexual abuse where the offender is under 17 years old, the victim is 9 to 17 years old, and the offender uses force or the threat of force. 720 ILCS 5/11-1.60d, sexual penetration or sexual conduct against victim between 13 and 17 years old, in which the offender is at least 5 years older than victim. 720 ILCS 5/11-1.60f, aggravated criminal sexual abuse, where the victim is under 18 years old and the offender is over 17 years old and has a position of power or authority over victim. Finally, the offense of patronizing a sexually exploited child is covered in 720 ILCS 5/11-18.1. This offense occurs in Chicago and Cook County when a person sexually penetrates a person under 18 years old who is engaged in prostitution, touches or fondles a sexually exploited child with the intent to sexually gratify themselves. Statutory rape sentence in Chicago, Illinois. In the same way that statutory rape offense are covered throughout different Illinois laws, the penalties for these offenses are also spread throughout their respective statutes and vary. Statutory rape is virtually always charged as a felony in Chicago. The felony penalty an offender faces varies based on the nature of the statutory rape offense they commit. The penalties for predatory criminal sexual assault of a child are laid out in 720 ILCS 5/11-1.40b. The base level charge is a Class X felony, with a possible prison sentence between 6 and 60 years, but any prison sentence for a conviction is subject to sentencing enhancements based on the following factors. Predatory criminal sexual assault of a child while armed with a firearm adds 15 additional years to the underlying prison sentence. Predatory criminal sexual assault of a child while discharging a firearm adds 20 additional years to the underlying prison sentence. Predatory criminal sexual assault of a child while drugging the victim results in a 50-year minimum prison sentence. Predatory criminal sexual assault of a child while causing great bodily harm to the child, results in a prison sentence of 50 years to life. The standard penalty for criminal sexual assault in Illinois is a Class 1 felony, even for statutory rape offenses committed against minors. However, a second violation will result in a Class X felony charge. The sentencing portion of the statute, 720 ILCS 5/11-1.20 B1 C, only calls for these second offense enhancements specifically when they are committed against minors. Aggravated criminal sexual assault charges, on the other hand, are always a Class X felonies in Illinois, regardless of whether or not the victim is a minor. Interestingly, the sentencing portion of the statute, 720 ILCS 5/11-1.30 D, only applies enhancements for aggravated sexual assault charges committed with a firearm. Age is not a factor in sentencing enhancements. The crime of criminal sexual abuse does outline age-related penalties, though only for sexual offenses committed by minor against other minors. While the standard charge is a Class 4 felony, an individual can be charged with a Class A misdemeanor for sexual abuse in Chicago and Cook County when the offender is under 17 years old and the victim is between 9 and 17 years old. The victim is between 13 and 17 years old and the offender is less than 5 years older than the victim. For the crime of aggravated criminal sexual abuse, the sentencing guidelines in 720 ILCS 5/11-1.60 G do cover statutory rape-related enhancements. The standard charge is a Class 2 felony, but in cases where the victim is under 18 years old and the offender is over 17 years old and hold a position of power or authority over their victim, the offender faces a Class 1 felony charge. Patronizing a sexually exploited child is a statutory rape offense by definition. The base-level charge is a Class 3 felony, but if the offense is someone's second or subsequent violation, or it occurs within 1,000 feet of a school, the offender will be charged with a Class 2 felony. Statutory rape and the sex offender registry in Chicago, Illinois. A statutory rape conviction in Chicago, Illinois requires mandatory registration on Illinois's sex offender registry. The Illinois Sex Offender Registration Act automatically defines individuals convicted of a statutory rape crime as sex offenders. As for the required duration of registration, a statutory rape conviction all but guarantees a required lifetime on the Illinois Sex Offender Registry. There are a few instances of individuals with no criminal history remaining registered for only 10 years for criminal sexual abuse convictions, but these cases are very rare. Registering as a sex offender in Illinois after a statutory rape conviction can come with several personal and social consequences that can follow an individual for the rest of their life. These may include, but are not limited to, housing issues. Registered sex offenders often struggle to find housing because landlords, apartment complexes, and residency restrictions can severely limit where they are legally allowed to live in Chicago. Employment restraints. Many Chicago employers refuse to hire registered sex offenders, especially for jobs involving children, education, health care, government work, licensing, or positions requiring background checks and professional certifications. Orders of protection. Statutory rape allegations or convictions may lead Cook County courts to issue protective orders restricting contact with alleged victims, families, schools, homes, or other locations throughout the Chicago area. Child custody and visitation problems. Cook County family courts may restrict custody or visitation rights after a statutory rape conviction, particularly when children are involved or judges believe contact could endanger a child's welfare. The loss of firearm rights. A felony statutory rape conviction can permanently eliminate firearm ownership rights under Illinois and federal law, preventing individuals from legally possessing or purchasing guns or ammunition in Chicago or Cook County. Immigration consequences. Non-citizens convicted of statutory rape-related offenses may face deportation, inadmissibility, visa denials, green card problems, or removal proceedings under federal immigration laws governing sex crimes. Criminal defense strategies against Chicago, Illinois. Statutory rape charges. Statutory rape is one of the most serious charges someone in Chicago could face. At Combs Waterkotte, our criminal defense attorneys have defended Chicago residents against statutory rape charges in the past, and we've found the following criminal defense strategies to be very effective at securing desirable outcomes in these cases. Challenging the alleged victim's age. In some Chicago statutory rape prosecutions, the defense may focus on whether the state can actually prove the alleged victim's age beyond a reasonable doubt. Defense attorneys often scrutinize birth records, school records, social media accounts, text messages, and online dating profiles for any inconsistencies. In Cook County cases involving online communication, a lawyer may be able to argue the defendant reasonably believed the alleged victim was older than they actually are based on false age-related claims made through apps, messages, or using fake identification. Weak or contradictory age evidence can create reasonable doubt at trial. Fighting exaggerated or false allegations. Defense attorneys in Chicago and Cook County statutory rape cases often investigate whether allegations were exaggerated, distorted, or entirely fabricated. Lawyers may examine text messages, social media posts, prior statements, and witness accounts to uncover inconsistencies in the accuser's story. In some Cook County prosecutions, allegations arise after family disputes, school discipline issues, or pressure from parents or investigators. The defense may argue the accusations changed over time or were influenced by outside motivations. Demonstrating credibility problems can create reasonable doubt and significantly weaken the prosecution's case before trial. Challenging DNA and forensic evidence. Cook County prosecutors frequently rely on DNA evidence to strengthen statutory rape allegations, but forensic evidence is not always as definitive as it may appear. Defense attorneys often challenge how biological samples were collected, stored, tested, or interpreted by investigators. In Chicago sexual assault cases, lawyers can scrutinize chain of custody issues, lab errors, contamination issues, or incomplete testing procedures. Even if DNA establishes sexual contact, it may not prove when the contact occurred or whether the alleged facts are accurate. Undermining forensic evidence can reduce the credibility and greatly aid in a statutory rape defense. Using an alibi defense. An alibi defense can be highly effective when prosecutors claim a specific sexual encounter occurred at a particular time and place in Chicago. Defense attorneys may present work records, GPS data, surveillance footage, rideshare receipts, hotel records, or witness testimony showing the defendant was elsewhere at the time of the offense. Lawyers frequently use cell phone location data and digital timestamps to undermine the prosecution's timeline. Because many statutory rape cases involve delayed reporting, proving the defendant could not have been present during the supposed encounter may seriously weaken the state's case. Challenging illegal searches of phones and digital accounts. Chicago statutory rape investigations typically involve aggressive searches of phones, computers, social media accounts, and other data. Defense attorneys file Fourth Amendment motions arguing police conducted unlawful searches or exceeded the scope of a warrant. If investigators improperly accessed text messages, dating apps, private photographs, or the defendant's internet history, the defense may seek to suppress that evidence. In some Cook County prosecutions, excluding unlawfully obtained digital evidence can significantly damage the state's case and improve the defendant's chances of dismissal, acquittal, or favorable plea negotiations. Suppressing statements taken in violation of Miranda rights. Chicago police frequently attempt to obtain incriminating statements during statutory rape investigations before formal charges are ever filed. A Chicago criminal defense lawyer might be able to assert that investigators violated the defendant's Miranda rights or used coercive interrogation tactics to coerce a confession. If officers continued questioning after the defendant requested an attorney or failed to properly advise them of their constitutional rights, the court may grant the defense's motion to suppress those statements. Because prosecutors often rely heavily on admissions in statutory rape cases, excluding a confession or damaging statement can dramatically weaken the prosecution's evidence. Attacking the credibility of delayed allegations. Many statutory rape allegations in Illinois surface weeks, months, or even years after the alleged conduct occurred. In these instances, defense lawyers often focus on inconsistencies in the accuser's statements, changing timelines, missing evidence, or outside motives influencing the accusation. In Chicago, cases involving former relationships, family disputes, or school conflicts, attorneys may argue the allegations were exaggerated or fabricated after the relationship ended. The defense may also highlight an absence of physical evidence or contemporaneous reports to challenge whether prosecutors can actually prove the allegations beyond a reasonable doubt. Negotiating with the prosecution. Oftentimes in Chicago statutory rape cases, the primary defense goal is avoiding mandatory sex offender registration under Illinois' Sex Offender Registration Act (SORA) laws. An experienced criminal defense attorney may be able to negotiate for reduced or amended charges that do not trigger registration requirements and that come with shorter or no prison sentences. Lawyers often emphasize mitigating factors such as close age differences, consensual relationships, lack of force, a clean criminal history, and weaknesses in the evidence. Because sex offender registration or felony sex offense convictions can affect employment, housing, education, and reputation for decades, strategic plea negotiations are often just as important as defending the case at trial. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.